Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and a very good day to everyone. In our previous lesson, we have already covered the overview of historical theory of law, and we have mentioned that there are two historical law jurists, Savigny and Maine. In this video, we are going to talk about the ideology of the first historical jurist. It's called Savigny, and for this purpose I highly recommend you to refer to this mind map, which has already been provided through our online learning, so that you can follow through the discussion in this video. Let's go ahead. What is it that we are going to cover in this video lesson is about Savigny's theory. There are three things altogether. The first one, we're going to talk about the background of Savigny and his ideology. Number two, we're going to talk about contributions of that ideology. And number three, we're going to talk about drawbacks and criticism. First thing first, who is Savigny? Okay, Savigny, he is a German philosopher, and he founded the historical thought. Okay, the underlying principles of historical school of thought comes from his ideology, which becomes the basis of the theory for the following historical jurists as well. Now, why did he come up with the new theory called historical theory? It is in response to the French Revolution, whereby he has seen that the revolution that is taking place in France, and he is not happy with the importation of law in France, as well as the democracy movement in India, whereby the importation of other laws which have impeded or diluted the local ideologies in France as well as India. So out of that, Savigny come up with the idea of Volksgeist. Okay, Volksgeist literally means people's spirit. Okay, it comes from the people, for the people, through the people. Okay, whereby the idea is whatever law that we have at present, it must be a reflection of the majority. What the majority regards it as law, and it becomes law. So Volksgeist is a principle that supports the power within the people themselves to recognize a certain piece of rule as law or otherwise. Okay, it falls back to what is practiced or the customary practices of the majority of the people in that situation. Okay, so if it is practiced or observed, if a certain rule is observed, then it is regarded as law. If a certain rule is there but it is not observed by the people, then according to Savigny, it is not law. Okay, law is what is being practiced or custom by the people. Why? Because it comes from the common consciousness of the majority number of people. Okay, it's not top-down approach, it's not natural law, but it is something what the majority of people regards it as law. Now, his thoughts of Volksgeist further developed into the thoughts of living law. Okay, now living law means whatever that is living in the society, what is observed in the society, it is regarded as law, living law. Now, for that purpose, law is not created. Okay, you cannot suddenly create law for the purpose of binding on the people, but actually law is recorded. What is the practice of the people? Then only we record the practices of the people as our law. Okay, it's not the other way around. It's not law coming first. It is actually coming from the society which regards a certain law as law. Then they will be recorded as law. Now, a historical theory of law actually is focusing on the study of the grassroots of the society, what the society wants, what the society lives. Now, it is compared with language. We have already mentioned this in our previous class. Savigny, or historical jurist, compares law with language. If the society speaks that language, then it is a living language. If they don't speak it, it's a dead language. Likewise, law. If the people practice such law, then it is regarded as living law. Otherwise, it is dead law. Now, after we have covered the basics or the background of the Savigny's historical theory of law, let's talk about the contributions of this ideology. Okay, how does Savigny's theory of law contributes towards the development of law? Okay, number one, law develops like a language. Okay, law develops like a language. It lives with the people and it dies with the people. So let's compare this with any legal provision that we have in Malaysia nowadays. Is there any law at all that is being implemented, being enforced and observed? And is there any law at all that dies with the people, which is that is no longer applicable? Okay, we develop law if it is something that is observed by the people. Okay, now a lot of rules come up nowadays because of the development of the technology. For example, we have the cyber laws, okay, various cyber laws that we have, as opposed to any other rules that we may have repealed, we may have replaced, for example, or amended before. Also, law is also seen as spontaneous, okay, because whatever law, whatever principles or law or regulations that is being practiced by the people, okay, it becomes the law itself spontaneously, because at the early stages, law is what is regarded as binding by the people. Okay, so what if the people says is binding, then it is as such. So it can become spontaneous. Now, also, this theory opposed the codification of German law. Okay, why? Because they have seen the situation in France as well as in India. So Savigny says we don't want other laws to be influencing our laws. So let's minimize the codification of German law. So until today, Germans have limited codified laws. And finally, law is continuous and unbreakable. Okay, because we can say there is new law or there is old law, but because it is evolving with the people. Okay, whatever people continues to do it, okay, then that is why law is continuous as well as unbreakable. Now, of course, for every theory that we have out there, we can have the pros and cons. And pros is whatever that is regarded as contributing to the development of the law, but criticisms is what other authors or other jurists do not agree with the principles of Savigny's historical thought. Let's go to the first one. Now, when Romany law was introduced into France, okay, it is something that is not suitable for the situation in France, whereby Savigny, who is a Germany, he says we don't want such things to happen in German. Okay, now the criticism by the other jurists is that how can a person actually refer to Romany law for the purpose of the Germans? Okay, we're supposed to refer to the Germany law for the purpose of the Germans. Okay, now also it has been stated that the claims by Savigny is inconsistent. Okay, now he did not oppose to Romani law authors. Okay, a lot of references that is referring to Romani authors, but at the same time, he is opposed to the importation of Romani law into Germany, into German. Another thing is, although the principle of Volksgeist was introduced during this session, this era, okay, by Savigny, but other jurists have claimed that they did not get clear description of vote itself. Okay, we do not know, not insufficient information, okay, as to the description of vote. Okay, is it spiritual communion? Okay, whatever that they have agreed spiritually, okay, and which is still open for discussion. Is it by way of ideology? Is it by way of thinking? Is it by way of physical? Is it by way of spiritual, for example? Okay. As well, Savigny has also claimed or criticized for exaggerating customs. Customs is the normality in that society. Okay, it is a local nature and it might affect only a small population. However, Savigny has put a very high rank for customs, habits of the people, okay, so that it is considered as law. However, okay, criticism says you cannot put a very high standing to customs and it is actually exaggerated. And as well, Savigny also underrated legislation, okay, because when he says it lives with the people and dies with the people, in other words, it means law is made by the legislatures, okay, which is not actually well accepted by other juries, because other juries puts a certain level of emphasis to legislation or written rules. And finally, the criticism says, because you've been talking about custom and because you do not put so much emphasis into written laws, you also do not put emphasis onto case laws, okay, because case laws are decided by the courts, okay, based on the real circumstances of the disputing parties, which is actually case laws is a very recognized source of law. Okay, now by not giving attention to case law, Savigny was criticized for undermining the contribution of judges. Okay, all right, so that's all for our video lesson today. I hope you have gotten some new information from this session. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.